Francesca, can you tell us how artificial intelligence is traversing criminal trials in Europe at the moment?
Is that AI is increasingly used throughout the whole spectrum of criminal justice, broadly intended, meaning from surveillance, intelligence to policing, law enforcement, investigation, prosecution, so also the trial phase, and then even after, for example, in detention and prisons. So what we see, for example, during the investigation phase is police agents using systems for biometric identification, such as facial recognition technology. We've seen also risk assessment being used, and here is also interesting to see the interplay between law enforcement and also migration control. We have many systems in Europe, especially at EU level, where we would have risk assessment at the borders, risk assessment of travelers. So every time we take a flight, actually our data are assessed to see whether the traveler poses a risk to national security. So risk assessment is surely a big part of the picture. And then obviously it depends on the member state. What we also seen big debate, for example, predictive policing, for which Fair Trials did a lot of work on during the whole debate on the AI Act and the legislative process. Many civil society organizations, including you, were pushing for a prohibition. Now we will see to what extent it's a prohibition. There are many broad exceptions to that, but that's also obviously a topic of discussion. What is very interesting actually is not only the investigation, but also the prosecution, so the use of AI system at trial. What we see is AI being used to provide evidence. By this I mean, for example, let's take the case of facial recognition technology. So you would use it, for instance, during the investigation phase to identify suspect of crimes. Then you would collect other evidence, you would charge the person with the crime, and then during the trial phase, you would use facial recognition technology to actually identify the defendant as the person that was committing the crime, so locating the defendant at the crime scene. So we see how AI actually has multi-purposes. It can be used from the investigation to the trial phase to provide evidence of guilt.
Do you think that the use of AI in criminal proceedings is a blessing or a challenge for human rights?
And what I believe is that fair trial rights are there to balance power asymmetries that are inherently there in the criminal justice system between the state and the citizen that is subject to the criminal justice system. And I think AI has really the power to create new power asymmetries. And so for me that's a concern. It's a big concern because AI is not just the technology itself, it's who's behind it. It's private actors, companies that develop these systems, they sell it to public prosecutors, to police agents, promising certain benefits, which may be true, maybe not, for sure, but the problem is that you have these powerful actors, you have these private companies that keep information secret because of commercial interest, because of trade secrets, and these systems are so technically complex, but their impact is so important. Imagine if the evidence, the only evidence against a defendant in a criminal proceeding is generated by AI. So you must be able to challenge that evidence. And of course this creates practical challenges for defendants and their defense attorneys. Because first of all, you may not have access to information, but even if you have access to information, it's so technically complex to understand an AI system. So you would need technical expertise, and that's also expensive. So in that sense, I believe that the biggest challenge of AI is really creating new power asymmetries where suspect of crimes and accused of crimes are disempowered. And my fear is also that who will pay the consequences of this will be defendants with lack of economic resources, because you cannot afford an IT expert that allow you to understand how the system works so that you can challenge it. So in that sense, this is my biggest fear, but on a positive note, I think everybody can play a role to preserve fair trial rights in the age of AI. First and foremost, obviously, there is the role of member states and the role of law. So introducing legal requirements for AI systems in terms of admissibility, in terms of transparency. I think member states need to take a position in terms of what we can accept or not. Is predictive policing, for instance, inherently incompatible with the presumption of innocence? And if so, let's not use it, let's ban it. So member states can intervene in that sense. And when we talk about AI in the trial phase, we have admissibility rules of evidence. So we need to have new admissibility rules also for AI system. If, for example, an AI system claims to detect emotion from your face, that's something that has no scientific validity whatsoever. And in member states, obviously, it varies, but we have very strict rules in terms of what kind of scientific evidence we can introduce at trial. So let's apply the same. The fact that it's AI doesn't mean that we have to overcome all of our rules in terms of what is science, what is a reliable scientific method, just because it's AI. They should be subject to the same rigor that we hold for scientific evidence and experts when they are human. So even when they are artificial, they should be subject to the same rules, if not even stricter rules. And then I see a lot of room for practitioners, and of course, in that sense, really being aware of how these questions and how these challenges that AI brings are so important, and getting also technical training on how to deal with these new forms of evidence. And then finally, obviously, for civil society organizations, I think that what is really important is to raise awareness around how AI is profoundly shaping the criminal justice system. It's not just, there are novelties in that sense, and really these new power imbalances that AI creates needs to be addressed. And I see a big role for civil society organization in raising awareness also towards judges, towards the practitioners, towards the actors of the criminal justice systems.
Can you tell us what EU case law tells us so far about the understanding that courts have of these new developments through their judgments?
For sure. So, first of all, what we have seen is that by analyzing, let's say, litigation in the field of artificial intelligence, obviously it's a new field of litigation, it's very recent, it's growing. At the beginning, obviously, there were problems in the sense that when people are not fully aware of how AI systems are used, it's hard to challenge them. You also, as I said, need technical expertise to challenge an AI system because you need to understand what is the system actually doing. So at the beginning, this is a new wave of litigation, but what we see is that courts are dealing with very, very similar legal questions. So, because they are legal questions really that are at the intersection between technology and human rights. So what we see, for example, is one of the legal questions the courts are addressing is, for example, when we take machine learning system based on self-learning, so continuously evolving, continuously changing its parameters to take the decision, courts are asking, is this inherently incompatible with the principle of legal certainty? And for example, the Court of Justice of the European Union in a recent case said, yes, it is incompatible because I need to challenge that decision. I need to know on the basis of what the decision was taken. And if these parameters and criteria are constantly changing, I cannot do that. Another question that I think is very, very interesting is with regard to the use of AI systems that are opaque and so technically complex that you cannot understand how they work. And when they're using criminal justice, courts are asking, is this inherently incompatible with the right of defendants to challenge adverse evidence, the right to confrontation? And we see a development of judicial responses in that sense. For example, in the US, courts have changed their opinion throughout time. At the beginning, they were against providing information about the software, so they were protecting trade secrecy by the companies that were developing these systems. And now, actually, they changing opinion in that sense. So a very recent judgment said that if facial recognition is used in criminal trials, defendants have the right to access the source code to assess the reliability of that evidence. Another important question that's been addressed, especially in Latin America and now in Europe as well, is whether live facial recognition is inherently compatible with the right to privacy. And for example, what we see in Europe is that the European Court of Human Rights delivered the first judgment ever on facial recognition technology in July, and it held that actually the benchmark of justification that you need as a state to introduce facial recognition technology must be the highest possible because of the inherent harm that this technology poses, not only to the right to privacy, but also to the concept of democracy.
We know that you're currently working on a tech database to put all this information together. So can you tell us a bit about it?
Of course.
Why it is important?
Of course. So this is a new project. It's called Tech Litigation Database. And it's part of the AFAR project, and it's funded by the Volkswagen Foundation, and it will be launched very soon, probably end of April. So the idea of the tech litigation database was precisely to put together all this case law, because when researching AI and human rights, and you see so many judgments in that sense, and very similar legal questions, as I said before, and how courts are approaching these questions, I realized that it was so important to have a space where you could find all of these judgments. So that's the ambition of the database, to create a space where you can find all of these judgments in English, with an English summary and all the information that you need. Because obviously all of these judgments are often not translated in English, they're stored in national database you may not have access to. So really the idea of the database is to provide the first open, easily accessible platform where you could access all of these judgments. The ambition is to be global, and we will do this through the work of national rapporteurs that can report landmark cases in their own country. We adopt a very broad approach. Why? Because we want to understand how judges perceive this.
So thanks a lot, Francesca.
Thank you so much for this wonderful conversation.
Thank you.